number of legal challenges. More are set today. This is very different a situation than back in 2000 with Gore and Bush. Talk to us a little bit about that.
Well, I think there are at least three things that separate the challenge in 2000 from this challenge in 2020. Number one, and most importantly, perhaps, in 2000, you had one state that was outstanding and that was heavily contested and that mattered in the election result. Now you've got as many as 4 states. So now the president is going to have to be playing chess on a kind of 4-dimensional basis, not just one state. Second major difference is now you're talking about differences in thousands and thousands of votes, 10,000 in Georgia to as many as 50,000 or more in Pennsylvania and Michigan. And that's not like Florida at all, where the election was decided by a matter of 537 votes. Third thing that's different now is that George W. Bush in 2000 was actually trying to protect a lead in the count, a narrow lead, but a lead. And now you have the president losing in all 4 of the states that matter just on the counts as they have been tallied so far. It's much more difficult to try to get a court to throw out ballots to change the result in the election count. So that is, in all 3 ways, I think that is a very steep uphill climb for President Trump.
And so you're saying that it's a higher bar set for somebody who's behind than who's ahead?
A very much higher bar because courts are going to be much less inclined to get involved and to make it look like they are changing the outcome of an election. In 2000, the Supreme Court, in some sense, was simply validating what was the most likely outcome of the election, albeit a narrow one. Now, that the scenario is very different.
And let me ask you, as far as, because you and I had discussed these scenarios the other night, and one of the things that I thought was so interesting is the kinds of cases that the Supreme Court would really look at, because there are a whole bunch of different claims as far as voting irregularities, fraud, etc. But you divided them into legal issues and then also into factual issues. Can you explain a little bit about that?
Yeah, so the Supreme Court is not a court of what we call original jurisdiction. It is not a trial court. It's not a fancy trial court that sits in Washington, D.C. Instead, this is a court that hears purely legal disputes. It's about the application of the law itself. So what the Supreme Court is not going to get into is the question of whether the signature on the request for a mail-in ballot matches the signature on the actual ballot as it was mailed in. Those are not matters that the Supreme Court is ever going to get into. It will look at questions like, has the legislature changed the rules in some way, or sorry, have the state courts changed the rules in some way, or have federal courts tried to change the rules set by the legislature in some way? Because that's a matter, potentially at least, of constitutional and constitutional law and statutory law, and those are matters that the Supreme Court will hear. But all of these fraud claims about intensely factual matters are not things the Supreme Court is going to hear.
So when we talk about, you touched on a little bit, when we talk about the legal case that, you know, the Supreme Court would look at in Pennsylvania, and I guess just from what we've read in Wisconsin as well, organizations other than perhaps the executive branches or even on the county level made changes to state law without legislative approval to grant more time to get the ballots, the mail ballots in against the legislature's wishes in Pennsylvania. And so I'm wondering, talk to me a little bit about what's in the Constitution that would, you know, the Supreme Court could say that's a legitimate argument?
Well, the Constitution is very clear in its text that it is the state legislature that has the power to conduct or to set the rules for holding an election, even for federal offices like the president. It's not within the power of federal courts. It's not within the power of the Congress to set the manner in which the election is held and the rules under which the election is held. So that Constitution is clear about that. I think that issue may come before the court at some point, but we're still several steps down the road before that issue even gets to the Supreme Court. So one issue that would have to be decided, I think, possibly in the context of Pennsylvania and also possibly in the context of Wisconsin, is whether or not, in fact, the legislature did authorize these executive bodies to, quote unquote, change the rules in some way and to adapt them to the circumstances of the pandemic. So sometimes legislatures give executive bodies, including state elections commissions, the authority to adapt the election processes to the circumstances. And if that's the case, then the legislature has acted in a way to approve the actions of those bodies, and there really is no legal issue. I think that may be the case, for example, in Wisconsin, where the election commission has taken some action to adjust to the pandemic. The other case in Pennsylvania would involve the question of whether late arriving ballots that were mail-in ballots could be counted. And there the problem is that it's unlikely that there are even enough of those ballots outstanding to make any kind of difference in the outcome of the election. And if that's the case, if there are only, say, a few thousand of those ballots that actually arrived late after Election Day, that wouldn't make any difference, it appears, in Pennsylvania, where the margin is more like 50,000 or more votes for Joe Biden. So in that case, I doubt very seriously that even if in theory the Trump administration, the Trump campaign is correct, that the Supreme Court would hear that dispute, because it doesn't need to hear that dispute.
Because it wouldn't change the result.
Because it wouldn't change the result.
Well, let me ask you about another scenario. Let's just say for grins that, it would have potentially, changed the outcome in Pennsylvania. If I hear you correctly, the Supreme Court may still really not act because there are so many other votes in other states that Biden is ahead that it still wouldn't change anything. Is that right? That's right. If
Biden, continues to hold on to the leads, and it appears he will in Michigan and Wisconsin and Nevada, for example, I think he's there. I have to do the math in my head, but I think he's pretty close. And certainly if Arizona and Georgia come out his way, there's no question about it. The Supreme Court has discretion whether it hears cases at all. The Constitution only requires the Supreme Court to hear a very small number of cases, and they don't include election disputes.
So let me ask, as far as, just continuing on that theme, before the court decided to act, would they also have to look at the status of the other states to see if there would be a difference in anything? In other words, if they had, recounts in Wisconsin and Georgia, and if, the president were to, say, come back and have more votes in Arizona, would the courts have to really consider that before deciding we're not going to act?
Well, I do want to be clear. So the Supreme Court doesn't have to do anything. Mm-hmm. The Supreme Court ultimately acts on its own authority under the Constitution, and it can decide it's going to hear disputes even if they don't make a difference. I think it's unlikely, but they could. And then the other question, I think, would be, what would be the timing of the court's intervention? So in part, the court probably would want to wait before intervening to see how things shake out a bit. And then you can always say, well, the ballots have been segregated. If it turns out that they make a difference, say these late arriving ballots, the ballots have been segregated. We'll know whether it makes a difference in the outcome of the election. And we can wait to hear that, say, by the time the states begin certifying their election results. And we don't arrive to the point at which the court actually needs to intervene until December the 14th, or maybe it's December the 11th. I have to take a look. I'm sorry, by December the 8th, I think it is, the states have to certify their election results, and they get the benefit of the safe harbor provisions of federal law. And then the ballots will be opened later on in the week, and Congress will count them. So in theory, at least, the Supreme Court wouldn't have to act even through the end of the month or the beginning of next month, when I think by then it will be absolutely clear there will not only have been certification in all of these states, but there will have been recounts more than likely in these states.
Just continuing on that theme for a second, because the court doesn't have to act, and in these, certainly in Pennsylvania, but perhaps Wisconsin, where you have issues, potential constitutional issues, if legislatures' wishes are not being, if they're being overturned, and there's nothing in the law that the legislature allowed the executive branch or counties to make changes on the state's behalf. At some point, doesn't the Supreme Court have to, or shouldn't the Supreme Court take a stand to just kind of tighten things up so that, these issues don't keep coming up? I mean, if the issues keep coming up in election after election and the Supreme Court doesn't act, isn't that just causing a problem over and over again?
Yes, there's a constant tension in constitutional law. This is not just specific to voting. There's a constant tension in constitutional law about the extent to which the court should go ahead and expound on questions that are not immediately before it, in order so that we can have some certainty. And so even if Joe Biden clearly wins the election and does so in margins that are very safe in all of these states, the court could decide that even in denying the petitions in front of it by the Trump campaign, it wants to make some kind of a statement. I do think a couple of justices on the court have already made statements that indicate quite clearly that they believe that it's the state legislatures that have the final say in the way that the votes are counted for the presidential elections. And they don't believe that state courts have any role in changing those rules. There's a little bit of mystery about how, say, Justice Barrett would rule on these kinds of questions. But I'm guessing they're going to leave it out for another election until it's really necessary. That's not out of the question, but unlikely.
And obviously, there's nothing stopping any of these state legislatures to tighten their laws.
Absolutely, nothing whatsoever. As long as they don't discriminate on some impermissible basis in conducting their elections under the Constitution, they are free to say, we're not going to have mail-in balloting, or we're going to require all kinds of voter ID that the Supreme Court has approved, or we are not going to allow you to extend the time in which the ballots can arrive after Election Day. That's clear.
And also, only we can set law and set the rules, and nobody else can make any changes.
That's right. They could rein in the authority of state election commissions so that the state election commissions are not given a broad grant of discretion to decide these matters in ways that they think are appropriate.
My final question to you is, with some of these other complaints about voting irregularities, maybe machines having mistakes, etc., the factual cases, as we discussed before, is there any scenario that an issue with that, having gone through either the state or federal courts, could wind up at the Supreme Court, or no?
Sure, that's possible. So if it turns out that there were truly systemic errors in the vote count, say, for example, because of a defective vote counting machine, You could have an intensely factual question about what then that amount of vote error amounts to and whether it changes the outcome. And you could have a very difficult legal question about what the remedy should be in the case that there was a systemic error. So there might be a desire to allow voters' votes to continue to count because they relied on these processes, but it might be the case that they shouldn't count because we don't know how they would actually have voted if the counting had gone according to plan. That kind of an issue, if it's at least factually determined at the lower level, could turn into a legal issue about what the remedy should be. And there you could have real disagreement in the courts and ultimately in the Supreme Court. Although, again, I would hasten to add or caution that we actually so far don't have evidence of that kind of systemic error, at least not so far.
Right. And that being the case, even then, I would imagine that's a very high bar to clear.
Absolutely, because again, you've got the question, you've got both the actual question of whether the errors would have changed the ultimate outcome, both at the state level and around the country. And you've got the factual question of the legal question, I suppose, ultimately of what to do about that fact. Let's hope that the Supreme Court doesn't have to step in those kind of circumstances to change the outcome of the election. And I don't think that's going to happen.
All right. Dale Carpenter, SMU constitutional law professor, thank you so much for your time and all of your insight today. Really appreciate it.
Hey, North Texas.
How'd it do?
You're staying home. I'm staying home.
Yeah, that's the stuff.
So we can just do this together, huh? By watching The King of Queens.
So all we do is watch TV all the time.
This is what works, huh?
Watch The King of Queens weeknights at 9 on TX.